Good evening, everyone. On behalf of AGBU, I would like to welcome you all and thank you for being here with us today. The ongoing war and violence perpetrated by the Azerbaijani government on Nagorno-Karabakh or Artsakh has led to a big number of casualties and the mass displacement of the Armenian people in the region. It has fueled the fire of long-standing protracted conflict in Nagorno-Karabakh and between Armenia and Azerbaijan, giving rise to political upheavals in Armenia itself. From the heavy historical burdens to present-day geopolitical realities, this lecture series raises critical awareness on the implications of war, destruction, and violence, and the possibilities to pacify a region shaken by crisis. This lecture is the second of the Artsakh series and brings together law experts to encompass the variety of topics to frame the Nagorno-Karabakh conflict around the various international law perspectives. Earlier in 2020, the Lepsius Haus, which is a research center for genocide studies in Germany, and the Armenian General Benevolent Union in Lebanon signed a memorandum of understanding to promote joint collaboration and establish a mutually beneficial relationship built on cooperation. And the Artsakh series is the first outcome of this partnership. I would like to let you all know that this webinar is live streamed on the AGBU Lebanon Facebook page, and it is recorded. Now, I would like to welcome Dr. Roy Knocke, the Deputy Director of Lepsius Haus, to deliver his opening remarks and who will be moderating today's event.
Yeah, Liana, thanks for the welcome and the kind remarks. So last year in December, the International Court of Justice called on Azerbaijan to protect Armenian prisoners and to end the desecration of Armenian cultural heritage. So we take these recent developments as an opportunity to discuss the numerous aspects of international law connected to the Nagorno-Karabakh conflict. So, and I welcome our speakers at this point, who are all legal experts. So Sarah Babaian, who is a professional negotiation expert and conflict manager for national and international conflicts. And in 2017, she founded her own negotiation and conflict consulting. Gurgen Petrossian, he is a senior researcher and head of the University Erlangen-Nürnberg's International Criminal Law Research Group, and Arlette Zakarian, who practices law with a focus on criminal law, labor and social law, and international and European Union law. So what we want to do today is we have 3 topics. And there will be, for each topic, there will be a kickoff presentation of around about 10 minutes. And then we can discuss this topic further. So that means you, the audience, you are invited to write questions in the Q&A section down below in Zoom or on Facebook. And we will incorporate these questions and these aspects in the discussion. So we don't have an extra Q&A at the end or for each topic, but we will bring the questions into the discussion together. So if we have a comment or a question, please feel free to write it down, and it will be taken care of. So we have 3 parts. The first part is on the question of the right of self-determination in international law. The second part will be on the violation of human rights. And the third part will be questions of law in the post-conflict area, like questions of prisoners of war or the big question of landmines. So we have these different things. I mean, you know, I'm not a lawyer, but we have 3 legal experts. So, but I think we can get away with that and somehow get into the questions which really matter, not only on the juridical level. Okay, so far so good. I guess Sarah, you can start with your kickoff presentation, and then we go from there and see what the evening brings.
Yes, thank you very much, Roy. Of a secession from the Republic of Azerbaijan to form its own and independent state, or to join another state, in this case Armenia. Even though the principle of the right to self-determination with its strongest form of secession is so often mentioned, I think that most of the people are not really aware of how the claim of this right arises and why states actually do not have to be so fearful in order to implement it. And the analysis of international law is based on the balancing of the universal applicable principles of the right of peoples to self-determination on the one hand, and the sovereignty of states on the other hand. And I think we all, as Armenians, know the incidents of the last 100 years, but also the Third War with all its consequences, once again demonstrated how essential it is to clarify the question of the legality of a possible secession of Nagorno-Karabakh in order to finally bring about a peaceful, but all about a lasting solution. The right to self-determination is a very old construct. This principle manifested itself through the two world wars, in particular through the codification in the UN Charter, but also in other human rights covenants. And the most specific definition of the right to self-determination is found in the Friendly Relations Declaration. And it talks about three possibilities how this status can be achieved. So either it is the establishment of a sovereign and independent state, or the free association with an independent state, or a free incorporation into such a state. This is what the self-determination talks about. So but the question is a bit like, what requirements does the right to self-determination really has, and what requirements have to be met? And it's very interesting because it is the scope of the right to self-determination is three-stage test. So first of all, you have to have the internal right to self-determination, then you have the external right to self-determination, and then the people who are claiming the right to self-determination have to be the holders of the right to self-determination. And it has to be the internal and the external part have to be distinguished because they stand in a gradual relationship. That means that the external right to self-determination only implies insofar as the internal right to self-determination has been withheld from the people. So what is the internal right to self-determination? So it covers not only the right to determine the political form of government, but also the right to exert influence and freely decide on its cultural development. And modalities of self-determination, first, for example, are autonomy models, federal state structures, and sufficient participation of all peoples in a democratically constituted state system. And in addition, we have to say that if the people claiming self-determination are an ethnic minority, they also can assert the defensive internal right of self-determination. We will come to this a bit later. So it is only when this autonomy in the internal self-determination has been denied that the inner self-determination strengthens into the outer self-determination. And the outer self-determination is really, it's the external offensive right. So it only comes into play when the internal, what I just said, the autonomy models, for example, or federal state structures have been denied. And so it is only applicable in such a case. So the choice of the internal political status of the people can be then accompanied with a change of territorial borders. And this is what states are so afraid of. Yeah? And so you really it becomes clear that the change in territorial status resulting from the right of secession contradicts to the norm of territorial, the territorial inviolability of states. So this is like the linkage, first internal, then external. And and then what I said, the people have to be the bearers of the right to self-determination. And so it has to be the people in the sense of the self-determination. And I think because of the lack of time, we cannot go too much into it, but it talks about subjective and objective components. And I think we are pretty clear that the Armenians in Nagorno-Karabakh are people in the sense of self-determination. So if we jump into the improvement, like what do we have the last 100 years? We have to see, okay, was there ever an autonomy status? And I think that's the big problem, because since 1921, it was really like that. There was never a really autonomy status. It was never implemented. Azerbaijani laws were implemented instead of Armenian laws. I mean, we are talking about a purely 98% of the people living in Nagorno-Karabakh were Armenians, but still Azerbaijani laws were only granted, and Armenians were not even part of the ministry. Then the Armenian language has been mentioned less and less over the years. Petitions were written in many years, so maybe to really tell you, it was in 27, 29, 35, 944, 68. I mean, there were so many petitions where the people really claimed and said something is going on here, and we don't have any kind of autonomy. So the people in between the 100 years always showed up. They always claimed that there was never such an autonomy status. And yeah, and even after the breakdown of the UdSSR, and when they proclaimed the Republic of Nagorno-Karabakh, the Azerbaijani forces revoked the autonomy altogether. So it has or can be determined that there was never ever a really autonomy status. Furthermore, it was the question that there was a big, I mean, human rights have to be respected in such times. And it could be shown that the government systematically discriminated the Armenians since 1920. And it was just to mention a few things. It was like schools, subjects were cancelled, the textbooks weren't given in Armenian language, churches were closed, clergy imprisoned, intellectual banned, whole villages just disappeared, population was expelled, and then there was the very bad Sumgayit massacre in 1988, and not to talk about the 91 Operation Ring, which was also called a genocide. Yeah, and then I mean, what we have seen the last 3 years also, or 2 years, what has happened in the war in 2020. And altogether, one can say that there was just ethnic discrimination. So all in all, one can say that the internal right to self-determination was not granted because there was no autonomy status, and furthermore, the people were discriminated. So it must be noted that it would reduce the right to self-determination absurd if people had to remain within the borders of a state, even if this state seriously violated the right to self-determination. So in summary, one can say that the ethnic group of the Armenians of Nagorno-Karabakh is, first of all, the bearer of the right to self-determination. Secondly, they were denied the exercise of the internal self-determination because the autonomy status was not given and did not exist, but was intentionally undermined by means of eliminating the Armenians. And yeah, so that the inner self-determination turns, like what I said, in the gradual relationship into the external self-determination. So in principle, one could say that the Armenian population of Nagorno-Karabakh has the right to establish a sovereign and independent state, or can be incorporated into an already existing state, in this case, Armenia. But unfortunately, this is not the end of the story. So as I said, there's also the other construct in the UN Charter, which is talking about the territorial integrity. And the Republic of Azerbaijan invokes the territorial integrity in this conflict. And one has to say that the territorial integrity is also one of the most fundamental norms in international law and is also referred to as a cornerstone or pillar. And so one has to see, like, how can one, it's called practical concordance, how can they come to a good solution in weighing them up with each other. In the past, it was really like that the right to self-determination was an absolute and permanent power, whereas today and extreme power and externally the independence. But sovereignty also, it's not it's a tough right, but it's not finds its limits in the right to self-determination, in human rights, as well as in the prohibition of violence and intervention. So one can see, or one has to see, that they are in a very great disproportion and in a very tension. So the task is now to bring both norms of international law to justifiable balance by means of this, as I called it already, practical concordance. And as we said, the principle of the territorial integrity is one of the most fundamental principles. And this is the reason why most of the states want to grant an absolute priority to this right. But, and I mean, it is, on the one hand, one has to say that it is understandable. So the solution of interstate conflicts should be first and foremost in the responsibility of the state concerned. And I mean, I'm totally with this. And it is intended to counteract the fragmentation of states, which is totally right. The softening of this principle could be a goal, like, for abusive efforts by third actors. And separatists could also use this as a force to achieve their goals. And secession, one has to say that as the outer part of self-determination, is the strongest form of self-determination and intervenes precisely in this firmly existing structures. But it also has to be said that an interpretation to the effect that the people must remain within the borders of a state, even if the state has seriously violated the right to internal self-determination of its people, would completely nullify the right to self-determination and render it void. Yeah? So a state authority that functions only as an oppression apparatus can hardly invoke its sovereignty with the argument of stability and thereby argue that secession poses a threat to it. Yeah? So in such a case, it must be particularly emphasized that the concrete will to the utmost form of self-determination only arises from the state's disregards for any interest of the community in human rights. So maybe let me repeat that. It is the duty of the state concerned to prevent secessionist aspirations of the people as the most serious consequence of external self-determination by granting internal self-determination. So the state in question can decide whether or not such a secession takes place. So the respect for internal self-determination is an extremely important, but above all, fundamental practical means of diffusing conflicts between different ethnic groups within the state. So if the will of the people is taken as a basis, such secessionist aspirations cannot arise. And as we have seen, or as I not seen, but as I told you, the Armenian population of Nagorno-Karabakh has been denied internal right of self-determination from the very beginning on, not just in the last 3 years, but we are talking about the last 100 years. Yeah. So if the exercise of the self-determination then represents the right of self-determination, like it's a remedial secession through which secession can be justified, because it can be only by the means of secession, it is possible for the people of Nagorno-Karabakh to preserve their human rights and to counteract further serious violations and to make use of their self-determination. So one has to say, in this special case of Nagorno-Karabakh, one has to say that the right to self-determination is weighing more, or is weighing more than the territorial integrity of of Nagorno-Karabakh. So yeah, like what I said, the Republic of Artsakh so has the power also over Nagorno-Karabakh. So in the end, one has to say that the people of Nagorno-Karabakh have the right to self-determination, either by saying they create their own state, or they create or they say they want to be part of Armenia. So this is a very specific analysis which always has to undergo these special steps in order to say, okay, in this case, the right to self-determination is weighing more than the territorial integrity of Azerbaijan. So I hope that got a bit clear, and yeah, maybe I can give it to you back, Roy.
I have two questions. I mean, one, if you say, I mean, of course, the pillars of international law, we have this territorial integrity aspects, and we have the right of self-determination. And the argument is of course a legal argument you get, but there's also a little bit of an historical argument in it. I mean, because you said that there was no autonomous status ever, and this is a problem for the law today. So that means we have to have this status at first, and then go from there. So do you have an example in the history of international law where that worked? I mean, or how that can work?
I mean, I don't think that it's a big problem to say if you grant. I mean, we all know the history of I mean, how it happened that Nagorno-Karabakh was implemented or was made a part of Azerbaijan. It never should be like that. Stalin said it's clear and obvious because of the ethnic group and because of this area being Armenian, that this has to go into Armenia. And then all of a sudden, just for political reasons, he decided otherwise. So if you grant an autonomy status, I think that's not a big, I mean, to say it very slappy, it's not a big deal to grant an autonomy status in between a state. But if the intention is just to really to continue what the Turks did with the Armenians, to just see that they want to have the whole territory Azerbaijani, I mean, then obviously the people aren't satisfied, and the people try to solve this in I mean, what they did in writing one petition after the other, and to say something is going on, here is no autonomy status. Yeah. So I think, I mean, there are, I think, states where this was implemented, but in the end, you see, like, if the big states want to have this whole territory their own, I mean, it's always a problem because they want to have this specific ethnic group out of their region, and in doing this by discriminating them, yeah, that's the best part, to either that the people flee, or that the people do not want to be part of this anymore. I don't know whether I don't know, Gurgen or Arlette, if you have an example in mind where this really worked. I mean, in long term, yeah, not just for a short time, but I mean in long term. Do you have an example?
I mean, and there is no face-to-face example you can give. It's very hard in international law,
Yeah.
Sarah mentioned. I would take the maybe the Yugoslavian war, and it's a European war, so it's quite close to us, and say the principle of Kosovo. Kosovo detached itself; it was part of Serbia, but Serbia is not recognizing Kosovo, and nor allies of Serbia, for example, Russia. But Kosovo is accepted from other countries. So it's not a clear, the same example, it's a parallel. But this problem is as old as the international law itself. You know, we can go to the First World War, we can say the Austrian-Hungarian Empire was also fell apart, and all different states came alive. So you have a bunch of things, and also colonization in France. But this is another story. There were colonies. They were not really this minority. So But you have a lot of illustrations you can go through in order to understand this process. And this process, as Sarah mentioned, is very hard, it's very long, and you need to have strong allies. That is the main issue.
So there's a comment by Ara Vasilian. She says, historically, the Nagorno-Karabakh autonomous with the Soviet Union as an administrative unit. Wouldn't that work as a legal basis of self-determination?
Yeah, if it would be implemented correctly, of course it would. I mean, the autonomy status as such, if it would have been granted as it should be, I don't think that I don't know if there would be really a problem. Gurgen, you wanted to say something?
I think the question relates to the autonomous oblasts within the Soviet Union, that they in late of 19 there was a law by the Soviet Union how the states or member states of the Soviet Union may actually exit the Soviet Union.
Yeah,
and the law has explicitly also mentioned what exactly will happen with the autonomous oblasts. So the law has given the opportunity also the oblasts to have a referendum to decide if they can go out from the member state itself or not. Yes, it gives a legal basis for self-determination. This is a correct question. But coming to also to the historical practices, to your question, Roy, I think international law is a very individual, maybe use only very individual cases. You cannot make really comparison between one particular conflict with another particular conflict. Even the similarities of different conflicts, you cannot compare with each other. Every single conflict is individual, and international law has fundamental principles like self-determination, like the territorial sovereignty, and other principles. But they have to be balanced according to the facts that you have at the moment in your hand. And as Sarah very correctly mentioned, all that facts that were happening during the historically happening during the whole time, there are already enough to consider that in this particular case, we have the self-determination higher than the territorial integrity.
If I can just mention a little thing, when after the fall of the Soviet Union, Azerbaijan was created, actually one country was absolutely against this name because of this minority question, and this country was Iran. When Iran understood that Azerbaijan's name is going to be Azerbaijan, said, no, please change your name. We have minority, we have Azerbaijani minorities. They would have the bad idea then to come and annex, be part of your country. So this was Iran's fear, but it didn't come to play. So you have also the thing that Azerbaijan didn't exist before Soviet Union, and then after the fall of Soviet Union, it was created, and even the name was created. So whereas Nagorno-Karabakh existed very long, much longer.
And if I may say what also Gurgen correctly said, it is an additional argument what is always brought up, that pursuant to the law of the UdSSR, there is another. It's a further right to self-determination out of this law. So it's the question was perfectly right. So I mean, we have a self-determination right to self-determination out of the international law from the UN Charter or the Friendly Relations Declaration, like internationally. But we also have, in addition, this the right out of the domestic UdSSR law. So totally correct.
Okay, so yeah, thanks for the clarifications. Just another call to the audience. If you want to participate, just write down your question in the chat or in the Q&A section. So I think we can move on to the next topic and then maybe later on round everything up again. So the next topic will be part violations against human rights and the question of the international court's in this conflict. So Gurgen, please.
Thank you, Roy. It is also for me a great honor to be part of this panel, and of course to be a guest of AGBU Lebanon. And of course, it's always a pleasure, Roy, to be a guest in Lepsius Haus. I will maybe concentrate or address mostly two aspects on the violation of human rights. One from the perspective of the state responsibility, and the other one from the individual responsibility or individual criminal responsibility. As Sarah mentioned in her speech, how many human rights violations were happening during the first war, Nagorno-Karabakh war, before Nagorno-Karabakh war. It has not to be forgotten that this kind of human rights violations were continuing also after the war, after the first war, and it continued also during the second war, April War, fourth day, April War, and even after, and mostly in the third war, when we had massive violations of humanitarian law, we have war crimes. So what is also important that the audience or those specialists who are informed about the Nagorno-Karabakh conflict, they don't really, let's say there are lots of judicial mechanisms which enable solving or bringing these cases before the court to have a justice. And internationally, there are a bunch of these kind of instruments, such as, for example, European Court of Human Rights, or International Court of Justice, International Criminal Court, or maybe also even national domestic authorities, foreign authorities, let's say. So while considering this conflict, always the dispute goes in the politics. So always people speak about who is right, who is wrong. But let's not forget that in the 21st century, we have international instruments where we can go and find a justice. Because actually after the Second World War, it has been said that, or even before the Second World War, even after the First World War, it was said that all disputes must be solved in a peaceful manner, in negotiation, through the negotiations. But even negotiations are not coming to an end. It doesn't mean that the human rights violations should have been taken in place. So what is important? Let's make a short overview. What exactly is happening today before international court, and what kind of violations are at the moment observed or discussed before the court. So we have first institution is European Court for Human Rights, where either Armenia, both countries, Armenia and Azerbaijan, are member to the European Convention on Human Rights. Since 2015, and even before, actually, many applications were lodged before the court to raise all those violations which were happening in the front line, in the sense like on the basis of the humanitarian violations, such as people who were trespassing, or like they were kidnapped, or they were captured by the opposite authorities, and they were tortured, mostly in cases of Azerbaijani cases, where they're tortured and then brought back to Armenia, and they lodged applications before the court. And if we see the tendency, all those applications which are now in the process of being judged, we see that in most applications, the Armenian applicants have actually successful judgments. Successful, but in a sense that they are given a reparation order by the court, because the court found that there is a violation, human rights violation of the, they were tortured, they were killed, and so etc. Another issue relates also to the property. This is also an important aspect. This was another important maybe judgments in Chirakov against Armenia, or same Sargsyan against Azerbaijan. This is also very interesting judgments, which gives us, both of us, interesting points to sit and discuss what exactly the court has decided, and find maybe some kind of ideas on that, what to do next. Another Hungarian beheading in Hungary, the case of Ramil Safarov, which was also judged by the European Court of Human Rights in 2020, and it was stated by the court that in Azerbaijan there is an atmosphere of hate against Armenians, and indulgation of Ramil Safarov in Azerbaijan plays actually a role to build a symbol, a heroic symbol for those who kills Armenian. Unfortunately, this is a very tragic thing which happens not only on individual basis but on state basis, which is more and more dangerous, because when you give an example of a hero, so everyone in the state wants to follow that example, to do the same as that example. And actually, if we continue following that tendency, we see in 2020 and also in 2016, when the beheadings were happening during the armed conflict, and this is exactly this mirror effect that the people, the soldiers who were fighting, they found themselves in a situation to do the same in order to be glorified later in their own state. And in 2020, why these war crimes were actually happening and why the prisoners of war were tortured, were humiliated, because they were thinking that they will be granted and honored in their state for doing that, even considering that this what they conduct is a war crime. So we see that then on the bearing in mind, there will be more and more applications, and there are ongoing proceedings before the European Court of Human Rights. But this is on the state responsibility level in the regional human rights court. So let's go to the more international court, International Court of Justice. This is let's say a world court which decides disputes between the states. And we have the Convention anti-discrimination, anti-racial racial discrimination convention, which sets strict rules that the states have to follow and not to tolerate any kind of racial discrimination within their own systems. Unfortunately, even bearing the mind of Ramil Safarov case, we see that even after the war, after the third war of Nagorno-Karabakh, we see that the Azerbaijani authorities, bearing in mind that they have a judgment already before the European Court of Human Rights, they built a museum in the center of the capital city, humiliating the Armenian dignity. This is one of the biggest examples of the racial discrimination, racial hatred. And if we consider that with the Nuremberg principles and Nuremberg racial laws, we can do lots of comparisons to see how one particular society or part of society was discriminated during the Second World War, and how this part of society is discriminated under the Azerbaijani authorities. There are a lot of similarities. And this is also why, as Sarah again mentioned, the Armenian population of Nagorno-Karabakh cannot live within this kind of racial discrimination, because it will not survive that discrimination. The beheadings, the war crimes, the bombings, these are all examples of this racial discrimination. Of course, the proceedings before the International Court of Justice are ongoing, and these proceedings will last very long. and lots of communication will be done. Of course, from the Azerbaijani part is also launched a similar complaint against the Armenian government. But I think that this complaint is unfounded, and this is not. There are not enough evidence to claim that the Armenian authorities or Armenia spreads racial discrimination or racial hatred against the Azerbaijanis. All right, this is the state responsibility. Let's move to the individual criminal responsibility. There is an international criminal court which stands as a symbol for punishment for the crimes, war crimes, genocide, crimes against humanity. And this institution was created exactly for this kind of conflicts in order to prevent happening of this kind of conduct, because otherwise this will disorder the whole international peace and order. However, neither Armenia nor Azerbaijan, unfortunately, are not members of the ICC, which I personally, as a lawyer, I think it's very pity that none of them are still part of the ICC, because this could be also some kind of a preventive mechanism for them not to commit war crimes or other violations. Even the ICC does not have in this particular case a jurisdiction, does not mean that the international perpetrators of war criminals still cannot be punished for the perpetrations they have committed. In 2022 or even in the 21st century, the tendency goes in that direction that every domestic authority has the power to punish war criminals independent of the fact or regardless of their nationality, where exactly the crimes were committed and who exactly the crime has done. Since the Syrian war, Germany takes the ruling or the first role to punish those war criminals who were participating in different war crimes in the Syrian war. And Sweden, France, also that those countries who are really involved in the prosecution of the war crimes. And I do believe that today this is also another possibility, even disregard or even keeping in mind that the ICC does not have jurisdiction, but the other states should keep an eye on the war criminals who committed crimes during the second Nagorno-Karabakh war and the third Nagorno-Karabakh war. So I hope I could explain the differences and those important judicial proceedings which are happening, and I do believe that these proceedings will help at least to find a justice for the victims before the international institutions, in somehow, even if the conflict is not resolved, but the victims at least can find a justice. So I hope these kind of institutions will continue their work and will be fruitful. Thank you very much.
Yeah, Gurgen, thanks for your kickoff presentation. So you mentioned the aspect of hate speech. So could you say a little bit more about it? How to classify this in this framework you mentioned, and if there are any procedures going on in this case? I mean, especially, of course, asking. I mean, we live in modern times. Social media is omnipresent, and this also connects, of course, with this kind of media.
Indeed, the hate speech is in the presence of the social media has a huge role, and the hate speech may be represented through different ways. But important is not through the individuals, hate speech spread by individuals, but by the domestic authorities. And if we see the rhetoric of the authorities, Azerbaijani authorities, before the war, during the war, and after war, it is a clear example how one particular or how own population is motivated or incited by the hatred against one particular ethnic or national group. The usage such words as those dogs should be get out from our territories, or for example printing post stamps with the chemical I don't know, chemicals, the Armenians from Nagorno-Karabakh with the COVID-19, which has to be, which are considered as an infection. So this everything which comes from the authorities motivates individuals to commit the same things and to commit war crimes on the battlefield, on the ground, in the social media. This everything goes directly to the head of the authorities, head of state. And if that comes out from his mouth, then people are motivated to do that. They see, okay, he's doing that, so I can do that as the same. This is a very, very bad tendency. And in considering that the social media is actually available to everyone today, those kind of hate speeches are making available to everyone. It makes more dangerous the life between different groups. We have similar cases before the International Court of Justice. In case of the Ukraine-Russia, in case of Qatar and Emirates, under the same convention. But and also Georgia, Russia case, but the outcomes are very different and are based on very specific occasions.
Thanks. I think Arlette, yeah, okay.
Yes, if I can add, in order to illustrate what Gurgen is saying, when you talk also about hate speech, it was internationally very well recognized in front of the International Tribunal of Rwanda, where the Radio des Mille Collines was also perpetrating officially in the morning. The radio speaker was saying, "This house, go and kill the cockroaches," meaning the Tutsis that the Hutus had to kill. So this was the first precedent, and of course, then the ICC continued on this case law. So hate speech is also in America very, very, very strong and very punished. So it's not something very particular. It's, thank God, it's coming into also the international.
Oh yeah, and this is very, very good example. Thank you for reminding me that of the ICTR, the tribunal for Rwanda, who was observing the cases of genocide cases. This radio was called as a radio machete, and the voices from the radio were considered as a voice from the gut. The similar case we have before the International Military Tribunal in Nuremberg, where the Julius Streicher, who was the founder of the newspaper Stürmer, he was also spreading hate towards the Jews. And the military tribunal have found that his speeches, his text in the newspaper was considered as a poison in the minds, in the German minds, who were just following this kind of hate speech. This is also an excellent example to see how hatred or hate speech may really influence the whole population to commit crimes against another part of population.
Yeah, it's a very bad incentive. Yeah, some comments from the round table here or from our audience. No, so then I think we can move on to Arlette's presentation, the post-conflict or post-bellum or what you call it in the legal business. Yeah, okay.
So thank you very much. I'm very honored to be part of this conference, very interesting conference. Yes, my part is the third part. First thing first, when my students asked me, it was a couple of years ago, it asked me actually how was international law born. So I was like a little perplexed because I had to think. And because I'm talking to Lebanese Armenian community, they will understand. First thing, international law appeared first because of commerce. People wanted to make business, people wanted to make money, so they wanted to create a legal framework in order to have secure the business and their money in order to prosper. Second thing, why international law came into force was war. And this is the dynamic of international law, which consists of the perpetual search for international order, based on various European principles of justice and peace, because then you can make also business. However, nowadays, we notice that the term of war is disappearing from our legal literature, and also because people, diplomats, scholars tend to tiptoe around it, and they like more to use legal terms like threatening peace, the use of force. So we can illustrate this also lately by Vladimir Putin, who actually said you're not allowed to use the term war when we're talking about the Ukrainian-Russian conflict, where also a lot of former journalists were really in a hazard. They were really afraid to have repercussion because they were still in Moscow. So this is the way how international law is trying to deal with the concept of war. There is a very old concept after the Second World War and the atrocities that happened through the Second World War. The Charter of the United Nations was created, which was international framework in order how to use the force. How do you use the force, and who is in the force? There are many axes. For my case, let's try to, and I'm going to tell you the two parties, but this is also starting to get a blurry concept, because you are protecting during a war the civilians and you have the military forces. But then after September 11th, suddenly the Americans popped up the term of unlawful combatant. So what was it, military or not military? And they're sitting in Guantanamo until today. Then in our case, Nagorno-Karabakh, we had suddenly mercenaries from Syria getting paid in order to kill Armenians. So a little bit of salary, we don't want to use our boys, so we use other ones who are more experienced. So these terms of who is civilian, who is military was a little bit blurred. Then last example is with the beginning of the Ukrainian war, was that you had a lot of young men who were not in the military service then, who had actually the flag around their arm and saying, if necessary, I'm going to fight. So the international question was, okay, if a soldier, a Russian soldier, or Russian military kills this person, what is this person, a civilian or a military? So the terms are getting blurred. And also, you have in the international law, you have the word to how do you organize war? Because at the beginning they were bumping into each other, everybody killing each other. And then they said, no, maybe we should get organized, how we do before the war, what we do during the war, and what we do after the war. So the first thing, something happened after the war, with what's around 200 years ago. It was a guy, actually a businessman called Henri Dunant. Henri Dunant went to the Battle of Solferino, which was a Napoleon War with Austria and Italy. Italy wasn't really existing, but let's say Italy and France. And he saw that a battlefield, a disgusting battlefield with wounded people dying. So he said, we cannot do this. We have to do something. So what he created was the Red Cross. This was the first thing of humanitarian law. This was the first step where people said, okay, we have to do something about post law. And in this post law, is it what do we do with the prisoners? How do we treat them? When do we give them to the enemy's back? And then also, how do we disarm? When is actually the war ending? In the case of Nagorno-Karabakh, we don't have a peace agreement, we have a ceasefire. So only the guns stop smoking. So what do we do with all the individuals? What do we do with the country, with the territory, which is full of landmines? who is taking care of these landmines. So this conventional process of disarmament, which can be seen as a stepchild of the principle of the use of form, is also in constant flux. So as you can imagine, states are very slow in the United Nations. We have the veto rights of the permanent members of the Security Council. Nothing is going forward. So NGOs who were actually experts, and also NGOs who have also in the case of Nagorno-Karabakh to discover a lot of issues, sat together and said, we have to ban landmines and cluster bombs. What can we do? United Nations was not working. So they started to do lobbying. And there were 1,200 NGOs. So they managed that countries like Canada, Norway, Austria, other tiny and middle-sized countries come together and they created a convention which is called the Ottawa Convention from Canada, in order to ban landmine and cluster bombs. This is what they call hybrid diplomacy, because usually who is creating law? States. In this case, NGOs influence states, and law was created in that way. So this hybrid diplomacy was created, and this NGO, this 1,200 NGO, just for the side story, received the Peace Nobel Prize for that. In order for you to understand when we are talking about landmines and what cluster bombs are, landmines are small explosives which are placed below or on the surface of the ground and which are victim activated. This means when somebody is stepping on it, touching on it, approaching it, then it explodes. And it doesn't make the differentiation of if it's a soldier, of if it's a civilian, or if it's a child. And because the way touching on it, little children tend to think it's something to play. So next to that person is if it has surgery, because war surgeons rank them as among the worst injuries ever. They get crippled and they suffer social and psychological influences. And most of them in the civilians are also farmers, because they want to nourish their family. And if the farmer as a head of the family is injured, well, the whole family has a big economic issue. Next to that, you have cluster munitions, where the Ottawa Convention is also dealing with cluster munitions. These are offensive weapons that are dropped from the air, like the airplanes dropping them down, or fired from the ground. These objectives usually tend to neutralize the combat zone. However, they are absolutely imprecise, and 5 to 40% of these cluster munitions do not explode, and they turn into landmines. So according to Handicap International, 98% of the recorded victims are civilians, and 1/3 of them are children. In order, just tiny illustration, Syria actually in the Syrian war has this huge problem of landmines, and you guys live in Lebanon, so I don't have to explain to you that the North Lebanon and South Lebanon are also affected. You have 60 million square meters and mostly agricultural lands that became unfit for use in Lebanon. So you have this big problem due to the occupation from 75 to 1990, during to the Hebrew state during Israeli-Lebanese conflict in 2006, and so on. So just a tiny ironical note concerning the Ukraine crisis. Ukraine crisis, landmines are also a problem there, but Vladimir Zelensky, the president, awarded a mine detection dog with an award. The Jack Russell Terrier Patron was given an award because he detected 100 booby traps in Ukraine. So the Vladimir Zelensky actually thanked the four-leg trend for his selfless service. So just in order for you to see the framework of landmines, cluster bombs, and that there is the Ottawa Convention. 164 member states signed and ratified this convention. Turkey, we are not allowed to say Turkey anymore, so Turkey is part of this convention. They signed and ratified it. Unfortunately, neither Armenia nor Azerbaijan. But why are we looking then at this? First of all, let's see the fact situation. The situation in Nagorno-Karabakh. Nagorno-Karabakh is a region surrounding the surrounding area in Nagorno-Karabakh, and the region is considered as one of the most significant mined regions of the former Soviet Union. So we have actually in the zones of Agadam, Fuzuli, and Jabrail districts that both Azeris and Armenians qualify as carpets of landmines. So an estimated 69,000 residents in 60 villages in Armenia are affected by these problems. So Azerbaijan was saying that they were not using landmines, and they say they use landmines. So it's not very clear. However, we have journalists and NGOs on the field who are actually witnessing via photos. There is the Vice News reporters who established that cluster munition had been used against Armenian civilians in the town of Stepanakert, meaning that they were thrown around hospitals, around school, and around playgrounds. And they were coming from Russian brands. Moreover, Human Rights Watch said that Azerbaijan was using cluster bombs from Israeli-made hands. So on both sides at the end of the war said that they used actually anti-mines and cluster bombs. And the question is how, who is going to take care of this? Who is going to clean up the zone? Azerbaijan started to use legal arguments and started to say, there is the Ottawa Convention. So Armenia has to use the Ottawa Convention and to clean out, as is it seen in Ottawa Convention, all the landmines. Because now, in order for the Azeris to come and to live in the conquested territory. But it was a little bit Azerbaijan's arbitrariness of the international law, because Azerbaijan was referring on customary law. It was saying, okay, we know that Armenia didn't sign the Ottawa Convention, neither did it sign its protocols, but because of customary law, Armenia had to use the convention. Well, what we can ask Azerbaijan is, there is the principle of reciprocity. Why not Azerbaijan do the same thing? And plus, Azerbaijan has signed and ratified a lot of international conventions, how to deal with war, how to deal with the Geneva Convention. And they violated how to deal with prisoners of war. And they violated all these different conventions. So before using customary law, maybe use hard law, the real law that is ratified, so it goes straight into international law. So this is one argument we can counter against Azerbaijan. Second thing, Azerbaijan was saying there is an absolutely illegal conduct of Armenia because they trading prisoners of war versus the mats, the anti-landmine mats. They have to give us the mats in order for us to go and to demine the whole region. I was a little bit tricked about that because yes, knowing that it's a war, you are fighting one against the other, it's the strengths fight. How can we deal with that? And I looked about the case laws and I saw, was there a country where, yes, you were dealing with the anti-mine land mats. In that case, very, very, for Armenia, understandable way, they want to have their sons back. So they are giving bit by bit. They're saying, if you give us the prisoners, we give the mats. So there were other cases where they want economic contracts in order to make business. And I found a case, actually, it was in 2007, that after 41 years, Nicolas Sarkozy, the French president, handed Algeria a map of 11 million landmines laid by the French army during the 8-year war in 1962. So this is also a normal way to negotiate after the post-war. And it's a civil way in order to say, we need our, we need something, you have something, we try to find a way. And in Nicolas Sarkozy's way, it was a way to recognize that it was had a very, very bad decolonization process, a lot of tortures, and in order to have very good economic relationships with Algeria. Whereas in Azerbaijan and Armenia, the case was we wanted the young men and the prisoners of war back. So this kind of situation is also saying that de-mining the territory, even for Azerbaijan, is very costly. And next to it, it's very costly. You need also very much know-how. But you have to see who has the know-how, the people who are actually constructing the landmines. The multinationals and the weapon lobby who know how to create landmines. Actually, they have the know-how that when a mine is dropped, after 4 months, can be self-destructive, but it's costing a lot. And you have to know how you don't have any interest, let's put it that way, in order to sell it. So in order to come to my first idea of this hybrid diplomacy, to this way that NGOs together created this convention, they were non-state actors, and they fulfilled something really phenomenal and received a Nobel for that. Why not include into these non-state actors these armed constructors who are selling to Israel, who are selling, in this case, to Russia, their weapons, and Russia and Israel are selling it to Azerbaijan. So why not include these non-state actors and responsibilize them and tell them also, if there are, from your production, landmines on a territory, you have the obligation to go and demine the territory. So it's a kind of, let's say, brave idea, but there are movements to include the economy into classical international law. In Germany, there is a very, very new act coming into 2023. Gurgen knows it very well, where you see this kind of hybrid diplomacy. So the Supply Chain Act that you have to follow for a multinational until the end of your supply chain, and to control that there are no human rights violation, because if not, as a private entity, you can come in front of a court and be tried for crimes against humanity, for example. So maybe to take this kind of initiative and to put it into for the landmines, and in order for make people to live not to be victims, to continue to be victims after ceasefire and the end of the war for years and years with the situation, which is also for the scarcity of the land and of the people. If I can end with a tiny citation of Victor Hugo, who says, the future has many names. For the weak, it is the unattainable. For the fearful, it is the unknown. And for the brave, and I'm sure that we are part of the brave, it is an opportunity. Thank you very much.
Thanks, Arlette, for your kickoff presentation. Just a question of understanding. I mean, you made the differentiation between the ceasefire and the peace treaty, of course. So is there also a differentiation in law about landmines of obligations in both cases? Are they different, and how different? No.
No. No,
okay.
You can, after a ceasefire starts, because what is the aim of the ceasefire? That the civil population goes back to their territories, that the civil population takes up a normal life. If you have landmines around school, around the playground, you cannot go back.
Yeah, of course.
So this is, but the problem is that usually states will take this argument and say, oh, we didn't finish, let us finish, let us sign. And this is for our for Nagorno-Karabakh, long story. After the second conflict, there was also ceasefire. So but no, you should, it is legal obligation to do so.
Okay. Yeah, no. Okay, I thought I saw a question in the audience, but so the audience, you're free to ask. You're still with us all. I'm impressed. No, it's a good thing, I guess. So any comments from Sarah, Gurgen on this aspect? Maybe
Maybe you can, I mean, that's not an aspect, but just like if people are more interested in all these topics, we were just jumping in, that we have just released the book about Nagorno-Karabakh with all the special, yeah, perfect, and with all the different topics, but then very profound, very deeply. So, I mean, unfortunately, right now it's still in German, but I'm pretty sure that we will translate that. But whoever is interested, I think that's a good thing, because, I mean, we just could jump in now, but we have a very profound analysis from all the different sides. So I think it could be very interesting for the others.
Yeah, I mean, I totally agree. So this is this book just recently published. This publisher. So yeah, I totally agree. I mean, my lecture, as I said, I'm not a lawyer or a legal expert, but it's very well written. So you can take a look on different aspects of the international law and the Karabakh conflict. So yeah, but this was more like a, yeah, okay. Arlette? Okay, so I thought you raised the hand or not. Okay, so I think we are the brave, we should be brave and say we make a cut here. And for all of you joining us from Berlin or Potsdam, we will also have a book presentation of this book we mentioned, and go into further detail of these aspects in September. You will get an invite, of course, in the Lepsius Haus Potsdam. But for now, I want to thank you, Sarah, Gurgen, Arlette, for your time, for your interesting insights. Thank you, the audience, to be patient and stayed with us the time. And yeah, I wish everyone a nice and fine evening.
Thank you very much.
Yeah, thank you very much.
Thank you, everyone.